In this video, we'll discuss the second ground, that is subordinate or delegated legislation, how it could be declared as violative of the provisions as provided under Article 31B and the ninth schedule. So the acts and regulations included in the ninth schedule of the Constitution are protected under Article 31B against the ground of infringement of any fundamental rights, but not against any other grounds. The protection of Article 31B is available only to the acts or regulations placed in ninth schedule of the Constitution. If an act is placed under the ninth schedule, the protection of Article 31B will be available to such act, but this protection will not be available to the delegated legislation made under it, as it was decided in the leading case, Prayag Ice and Oil Mills versus Union of India in 1978. So Supreme Court expressed that delegated legislation may be challenged on the ground that it violates the Constitution, even though the enabling or parent act under which it has been made is protected by Article 31B. And now we'll go to the third ground, that is not following the procedure that is prescribed under the Constitution, and regarding that, the Supreme Court has made it clear that the excessive delegation is not permissible, and the very doctrine of excessive delegation has played important role in controlling the practice of delegated legislation. So excessive delegation is taken as an addiction of essential legislative functions by the legislature. The delegation must not be unguided and uncontrolled. If the delegation is excessive, the enabling act or parent act will be unconstitutional, as it was decided in Hamdard Dawakhana versus Union of India in 1960 by the Supreme Court. So, also in United States of America, also the Congress can delegate its legislative power to the executive, subject to the condition that it lays down the policies and prescribes sufficiently definite standards to guide the delegate. If the Congress delegates its lawmaking power to the executive without laying down the legislative policy or without prescribing sufficiently definite standards, the delegation will be invalid. It is to be noted that the delegatee cannot have more legislative power than that of the delegators, as also it was expressed the same view by our Supreme Court in Indian Oil Corporation versus Municipal Corporation in 1993 by our Supreme Court. So now we'll go to exactly how delegated legislation, the power conferred by the enabling or parent act, is made without following the procedure required by the enabling or parent act to be followed by the delegates as it was decided in Banwari Lal versus State of Bihar in 1961 by the Supreme Court. So, if it is made without following the procedure required by the Enabling Act, the delegated or subordinate legislation will be invalid on the ground that it is ultra vires. The Enabling or Parent Act, the validity of the exercise of power is tested on the basis of the standards to be followed as it was decided in the Prayag Mills versus Union of India in 1978. So the very ground also provides that when it is made in excess of the power conferred by the Enabling or Parent Act, the subordinate or delegated legislation is held to be ultra vires. The Enabling or Parent Act, it is found to be in excess of the power conferred by the Enabling Act as it was decided in Sri Sitaram Sugar Company versus Union of India in 1990. So, the very nature of delegation, if it is in conflict with the Enabling or Parent Act, would be declared as ultra vires. So also, if it is in conflict with the procedure prescribed by the Enabling and Parent Act, so in Raja Buland Sugar Company versus Rampur Municipality in 1965, the Supreme Court expressed that the UP Municipal Act 1916 provided that the draft rules must be published in a local Hindi Delhi, and the draft rule were published in a local Urdu Delhi. So here the substantive nature of publication is followed. So the very rule is not violating the provisions of the Enabling or Parent Act, so it was not declared as ultra vires. So, in some leading case, we will discuss whether the procedures are followed, the prescribed procedures. So, in that case, whether there is any reasonable or arbitrary use, in that case, we will discuss Air India versus Nargis Mirza in 1984, where a regulation provided that an air hostess should retire from the service attaining the age of 35 years or on marriage within 4 years of service or on forced pregnancy, whichever occurred earlier. The regulation authorized the managing director to extend the age of retirement to 45 years at his own option. If an air hostess was found medically fit, the regulation did not contain any guidelines or policy according to which the discretion conferred on the director was to be exercised. So the regulation and the very termination of the service of an air hostess is violative of Article 14, and it was unreasonable and arbitrary. And in the same way, in Central Inland Water Transport Corporation versus B.S. Ganguly, it was held that the Rule 9, Clause 1 of the Central Inland Water Transport Corporation Limited Service Disciplinary appeal rules of 1979 was struck down on the ground that it was arbitrary and unreasonable. And in the same way, in Delhi, Transport Corporation and Delhi Transport Mazdoor Congress, the very regulation was struck down. Regulation 9, Clause B of the Delhi Road Transport Authority was struck down regarding the conditions of appointment and service. Regulation 1952 on the ground that it was arbitrary and unreasonable and violative of Article 14. The said regulation 9. Clause B empowered the authority to terminate the services of a permanent and confirmed employee by issuing a notice without assigning any reason in order and without affording any opportunity of hearing to the employee before passing the order of termination. So it was held to be unreasonable, arbitrary, and violative of the principle of natural justice and Article 14 of the Constitution. So also it violates the very maxim odi alterum patum.